Hi, my name is Pallavi Prasad, and this evening we are focusing on amendments to India's Forest Conservation Act or the FCA. This is India's central law to prevent deforestation, and it essentially says that you need to take clearance from the central government before you divert a forest for any non-forestry purposes, anything related not related to conservation or not related to forestry. On October 2nd, the government proposed 14 changes to the FCA, which by and large seek to make it easier to do exactly these kind of diversions. For instance, the big changes say that no clearance is needed for diverting a certain kind of forest, such as forests in border areas or forests on private lands for non-forestry purposes. Even roadways and railways might get an exemption from seeking clearance to cut down forests for infra work in certain cases. We have done a video explaining these amendments, and I'll link that video in the description. But today I just wanted to go slightly deeper into the legal and technical details of these changes, which concern us all, especially as we see the climate crisis unfold. To that end, joining me today is Arpita Kodiveri. She is an environmental lawyer who has studied, tracked, and followed India's environmental laws closely, including frequent efforts to change them for better or for worse. Currently, she's doing her postdoctoral research at the Climate Litigation Accelerator at NYU School of Law, which is also where she is joining me from. Hi, Arpita. Thank you so much. Thanks for taking out the time for me today.
Thank you for having me and addressing such an important topic.
It's the only thing to do as journalists. So let's dive straight in. To start, can you set the context for these FCA amendments? Can you talk a little bit about how hard it is, how complicated it is to regulate forests, especially in a country like India? And over the past few years, what efforts have been made to change these for better or for worse? Also, why is it important that we have this context before we get into the amendments?
Right. So I think one of the biggest challenges in environmental law in India is regulating forests. And the reason I say that is because it has this complex situation where you have development requirements of a growing nation, you have rights of communities, who are dependent on these ecosystems, accompanied with the situation where you want to preserve these pristine natural spaces. Now, it's a collision course in that sense, right? If you look at it from a regulatory perspective, but it's not necessarily an unhealthy collision course, right? So essentially, what forest laws have tended to do is have very separate laws dealing with separate problems. So you have the Indian Forest Act, which was a British law actually, which kind of came into the Indian legal landscape post independence, which looked to preserve forest areas. So it created certain categories of forest areas. Unfortunately, that also created a paradigm of what we call exclusionary conservation. And so the forest rights of forest dwelling communities was not taken into account except under certain categories of forest. The reason I bring this sort of narrative of injustice out is for you to better locate these current set of amendments. And in 1980, when the government started to notice that deforestation was happening at a very rapid pace, it decided to centralize decision making. So that's when you have the Forest Conservation Act coming in, with a main purpose to look at how forest land is being used for what the law calls non-forestry purpose, but just to simplify it, for any kind of development project or where large amounts of forest land are being used for other purposes. And it was only in 2006 that you had the Forest Rights Act being passed, which recognized very assertively the rights of forest dwelling communities, both to forest land as well as for them to be part of decision making on conservation, and decision making when alienation of forest land happens through what we call a consent process. So once you start to see that there is sort of specific laws dealing with these specific problems, it's not that they don't interact. So it's also that they interact in very complicated ways. And that interaction actually has been both fruitful and problematic. Fruitful in the sense that with the consent provision under the Forest Rights Act, it democratizes decision making on how forest land gets diverted. But it's not been fruitful in situations where the Indian Forest Act conflicts with the Forest Rights Act in some ways. So what are rights then become offenses? Now I'm just setting this context, saying that these laws are in conflict, but they also are completely interconnected in very important ways. And these set of amendments are not cannot be seen in isolation of a series of amendments that have been proposed since 2014. Some are not forest laws, but broader enviro legal framework in general. So, if you look at, say, the EIA notification which they tried to amend, the essential tone and tenor of that set of amendments was what I call deregulation, or this ability of reducing legal scrutiny and removing the legal shield. And it did so by enabling industries to not have to go through the environmental clearance process, or there is a public hearing process, which again kind of got, one can say, shaved off in very specific ways. Similarly, with the Indian Forest Act, when they tried to amend it in 2019, was very problematic because it gave the Forest Department excess power, even to the extent of shoot at sight. So it was a very draconian attempt to amend the law. And then you have the FCA amendments as they have been proposed, and you've done a great job in breaking that down. So, one way to look at these FCA amendments is to see it in a larger project that I am starting to identify of deregulation of environmental safeguards, with the objective, I think, both for undoing what they call red tapeism or bureaucracy that comes with these clearance processes, as well as trying to create more room for industries to be able to operate off without such regulatory oversight. But I also wanted to make a quick, have to give the present government its due to some extent, right? Can't be all bad news. So, in that sense, they've actually rolled back on the proposed amendments of the Indian Forest Act, which had been outsourced to a private law firm. But now they've rolled it back and they're going to kind of take a revisit it, which is good news.
So that it gives me, you're saying that the overall gist of the FCA amendments is similar to previous attempts to amend the EIA or the other laws, which is deregulation in favor of industry, if I'm understanding right. Now, one of the things that activists and lawyers like you are saying is that these amendments essentially change the definition of what a forest is, which is at the heart of the FCA. Could you speak a bit about the definition of forest as it stands today and how the FCA amendment changes it and what happens after that?
Right. So it's an interesting story. So forests came to be defined in actually a public interest litigation filed before the Supreme Court. It's called the Godavarman Thirumalpad case. And in that, the Supreme Court took a very vast understanding of forest. It said any dictionary meaning of forest would tantamount to the legal definition of a forest. And this apart from forest which is recorded in government records and categorized legally before that. Now there are two ways to look at that can be sort of seen as a way in which you can extend protective environmental law onto many lands which can be considered forest, or it can also be seen as a situation where the government is a bit lost. Does this qualify as forest? Doesn't it qualify as forest? How do we regulate this particular geography? But in some ways, this wide definition has been interesting from an environmental lawyer's perspective, because then you start to say that so much land qualifies as forest land, hence protective laws apply. So it has a more vast scope of applicability. Now, the current set of amendments highlight the challenge that the government faces with this particular definition, and also how private individuals tend to suffer because of this very broad definition. But it tries to, curtail it in very interesting ways. One, what it does is it says if in private land, somebody decides to grow a forest or a plantation of some kind, that shouldn't be considered as forest, because then they're going to be limited by these forest laws, because you'd have to go through a forest clearance process, your rights over using this land gets restricted. But the counterpoint to that is, then how do we plan to protect these potential forests or these potential carbon offsets that the government kind of uses as the logic behind this particular situation, right? Similarly, the tricky thing that the amendments do is they create a set of exemptions or exceptions to the law, right? And in doing so, it creates categories which don't then fall within this forest land or definition or non forest purpose definition. So they're still playing with these two legal categories. So they say, for instance, forests which are in international border regions, and if we have to use it for strategic projects, then we don't need a forest clearance. So effectively, what are you doing if the law doesn't apply then to these particular forests? Are you kind of changing the definition of non-forest purpose, or are you changing the definition of forest land itself that the law will attract these provisions? So it's implicitly trying to do it. And it's just my sort of legal hunch that it might be reducing the scope slowly and steadily. The other thing it constantly talks about is confusion of legal categories of land. And that is a genuine concern. You do have situations I've seen in UP where forest land has also been recorded in the revenue records. But that confusion is, in some sense, being seen as an opportunity to clarify and limit the scope of forest land so they can enable easy acquisition, is the way I'm reading it. But the other challenge with these issues has been that it's just a set of issues. It doesn't really point out to which section is being amended and how. So, in some sense, as a lawyer, you just have to rely on your legal interpretive skills, which I'm trying to do. So, in some sense, most of these comments, when the eventual amendments come out, might not hold water.
Yeah, and we have to keep in mind that, you know, it's not just lawyers who are reading this document, it's regular people, civil society, who don't have a legal hunch to count on, and they're going off these suggestions, which until 2 days ago were only in English. So the final amendments might look quite different, as you rightly said. Before I go into some of the specific changes that I had questions about, I wanted to ask something about you, something you just said. The government's, the way I read it is that the government is justifying these amendments in a very counterintuitive way. They're saying that we need to increase forest cover to 33%, we need to increase our carbon sinks. How does that work when you are allowing for deforestation in certain areas? How do I make sense of this contradiction?
Right. I think that's a very important question. And that is a contradiction that you notice not just in the current set of proposed amendments, but also in a mechanism that we have called the Compensatory Afforestation Act. Um, the act itself is about compensating for the, after deforestation, how does one recreate these forests? And that's definitely counterintuitive. Instead of having a law that has strong teeth to prevent deforestation, you're sort of relying on more compensatory mechanisms of plantations and, compensatory forestation. And there are a lot of challenges with that approach because, like, I think even the note clarifies, the letter that they shared, that ownership in forest areas is a very uncertain terrain. So you don't know necessarily who owns the land. Usually it is the forest department that has control over the land. But community rights under the Forest Rights Act have not been recognized. Or land rights have been recognized but to not, the full capacity and scope. So then what happens is if they designate certain areas for plantations or compensatory forestation, it creates another layer of land conflicts where it sort of either takes away on community stewarded areas, or it kind of conflicts with other situations. So yeah, and this idea that private forests are going to come and save the day is perhaps a very narrow lens to be looking at amending these laws, instead of focusing more on the question of deforestation. The amendments do try to do that, though. They do speak about identifying what they call pristine forest areas and kind of leaving them, or like making sure that no development takes place for a certain period of time. But the challenge with that approach is, again, firstly, it's vague, so it's very difficult to comment on it. But what kind of scientific criteria would you use to define this pristine area? And what is the period of time that you're thinking of? And thirdly, how are you going to address the question of forest rights in these areas? So, like a similar attempt had been made where the Ministry of Environment and Forests had worked with the Ministry of Coal to create what they call go and no go areas. So we've had some experience in that, approach of creating spaces where no development takes place or no coal mining takes place. But it's been an administrative exercise. It's been subject to discretionary interpretation. So it's not necessarily panned out as they had hoped. So there have been ways in which no-go areas have been turned into go areas just for the convenience
Yeah.
of industry.
So I have a question specifically about the amendment relating to plantations. So please correct me if I am reading this wrong, but they are saying that if there is a forest on private land, which is called a forest based on the 1996 judgment, that person is the owner of that land is allowed to cut down that forest and grow a plantation there. And as in that should be their right. Is that what the amendment says?
So it's again a very good question, but also a tricky one to respond to. And the reason it's challenging is because the amendments in some ways says that they're trying to incentivize private plantations. And they're trying to incentivize private plantations by suggesting that if a private owner decides to grow certain kinds of trees, that it shouldn't amount to a forest, but it'll operate as a carbon sink. But for it to operate as a carbon sink, you have to make sure that it's not cut and the use is restricted. Now that's
Got
again
it.
going back to the age-old question of will the FCA and the IFA and other laws apply to this piece of land, not apply? What is going to be the regulatory solution for that? Is a question to the Ministry of Environment, Forests and Climate Change.
And are there any safeguards? Like, for instance, can this private person simply trade their forest land to corporations uh, once they are removed from the ambit of the FCA? And these corporations, for instance, like we say, like, what if they come up with big palm oil plantations? If is that something that is excluded from the FCA now, or are there separate rules that make sure that that can't happen? How will it work?
I think once it's excluded from the FCA, it's devoid of any regulatory oversight. It would be sort of then very basic criteria of perhaps depending on the kind of industry the person alienates the land to, maybe they have to get an EIA. Maybe that's not required either. So it is definitely going to be a gray area.
So a lot of this I'm sensing is gray area, especially because they've just put out suggestions. Um, I want to focus substantially on the rights of forest dwelling communities since it's also an area of expertise for you. But before that, I have one question relating to the amendment about railways and roadways being allowed to do infra work on land they acquired before 1980. Um, am I right in understanding that this includes land that could be a pristine or protected forest? So,
Absolutely.
th- so that's a green light. You can cut those.
Yeah, in some sense, it was such an interesting sort of stemming out of nowhere kind of amendment, and the reason I say that is because acquisition for linear projects is actually in many ways already subject to very few regulations. Of course, they do have to go through the Forest Rights Act and the Forest Conservation Act, but rightly so, because you don't know what kind of landscape it's going to cut through, right? Now, if we're looking at land which was acquired prior to 1980, that's going to be a whole set of new questions because what stage of acquisition is it at? You know, and has the project gone through? Has it received an environmental clearance? What is the nature of ownership of this land now? And we're talking about the post Forest Rights Act legal reality. So, are we looking at a situation then that in such a, if the land has already been acquired and communities are living on these pieces of land, are they going to be evicted? So it throws open a lot of questions. It seems like it's a very simple solution to a problem that the Ministry of Railways has been facing. But if you kind of put it in a new legal context, you realize that it's going to have adverse impacts, especially for forest dwelling communities and biodiversity.
But just to play devil's advocate here, though I hate that phrase, for railways, for instance, for linear projects, for laying down tracks, acquiring land is so time intensive. It takes years and years, maybe even decades, because even if they don't get that one small patch of land, they can't put that track, right? So suppose they have been acquiring land for a project and it has been these many years and a forest has naturally come up on those lands. How does one, the thing that you said, how does one balance development and connectivity with an inevitable consequence of how long it takes to acquire land in like far off areas?
Right. I think for this, I would say that first we need like good data, right, to make such complicated decisions. I think first we need to understand what are these railway projects, what kind of land qualifies for this exception, and then take into stock what kind of impact it's going to have and accordingly decide situations perhaps where this exemption is allowed. Maybe the project is in a very mature stage, compensation has already been given, the biodiversity impact is not so grave that you can still provide some kind of green signal for the project. The challenge also is that we are facing a climate crisis. So, in some sense, as we account for these exemptions, as we account for these, ways in which the act is not applying, we have to clarify what the climate impact is also going to be. So, we need to look at like three different layers of decision making. The rights of communities, biodiversity loss, as well as climate impact because you never know if this kind of goes through a catchment area or if it goes through a very important aquifer, then what is the long term impact going to be? Sadly, there isn't any solution when it comes to the question of time. I think, situations that are as complicated as this, you can be as quick as you possibly can, given the kind of bureaucracy that we have, but you can't afford to not do your due diligence in terms of your uh, looking into the long term situation that it will create.
So my understanding is that these, especially these big decisions, you have to take it on a case by case basis and sort of weigh the pros and cons, which is the perfect segue for my next question. Is when it comes to decision making for such projects, um, how do these FCA amendments sort of impact or sideline the tribals, the forest dwelling communities? If you can speak a little bit about how they disempower the Gram Sabhas from the power that they have currently, I think that is a very important part of these changes that's not making headlines. So I would like to spend some time on that.
Absolutely. So, one of the biggest kind of progressive legal achievements has been the recognition of the right of consent of the Gram Sabhas. This is especially after the Niyamgiri judgment. What that essentially means is that the Gram Sabha or the village assembly can either say yes or no to a project. And that actually is literally decentralizing decision making from the center. So, as part of the forest clearance process, the district collector will have to submit a resolution by the Gram Sabha saying that they agree or disagree to this project. Now, with the current FCA amendments, where they're creating these exceptions to the application of the act, whether it's for strategic projects or the kind of particular technology of oil drilling, or if we're looking at a situation with railways and roads, the Gram Sabha completely gets eliminated in that decision making process. So then alienation happens without even including their voice, and that's because their uh, voice is included specifically in the forest clearance process. And now, if you're saying no need or no requirement of the forest clearance process, then where do the Gram Sabhas fit in? There are, of course, provisions where if it's a scheduled area, then you have the Panchayat Extension of Scheduled Areas Act, but that's a lowest legal standard where you just have to consult the community. And in the environmental impact assessment, you just have a public hearing. So essentially, you have to hear what the community has to say, whether you listen or not is a choice. With the consent requirement, you have to, make sure that the community is on board. So now we're kind of taking away what is a very progressive legal achievement and diluting it entirely.
And not to forget that these changes or amendments are still only online and very recently were only converted to 11 other languages. So the people who are impacted the most are more or less just excluded from this consultation process. I do have a question about forest dwelling communities still. So in the beginning, you talked about how the amendments sort of say this is a forest, this is not a forest, and so you need clearance for this and you don't need clearance for that. So this sort of fragmentation of forest land, how does that impact their lives, especially, for instance, the one good change that pristine forests can't be touched? Does that include even by forest dwelling communities? So, how does this fragmentation impact the communities that have lived there traditionally?
Yeah, I think that's actually a much larger question. So it's not something that you can answer by just looking at these present set of amendments. The challenge for forest dwelling communities, despite the recognition of rights under the Forest Rights Act, has been that there have been challenges in implementing the act in what we call protected areas. So, for example, tiger reserves or national parks under the Wildlife Protection Act. And we even had a judgment as recent as February 2018, where we have a petition before the before the Supreme Court challenging the constitutionality of the Forest Rights Act, where it said that communities have to be evicted. The court went on to stay it, but essentially they've been struggling with this threat of eviction. And so now the fragmentation is adding to that particular situation where now you're going to say that alienation can occur in certain categories of land, but there might be communities dependent on those ecosystems. So maybe you have a situation where it's a project that might be exempt, or it's a project where it's a private plantation, but might also be a commons area for grazing. So in essence, communities tend to be disempowered by sort of state control in decision making, both in terms of application of or like restricting the application of the FCA, but also in changing these categories of land. Because suddenly, if the land is declared as not forest land, then the Forest Rights Act will not apply. So
So
it's
that's
a
why,
very complicated space.
which is why I guess the initial context that you gave, that all these laws are separate, but they are intertwined. I think that context is important. I do have one question about, um, in a sense, the amendment about private people are allowed to have make bona fide constructions on forest land already. Um, how does that A play out in a place like the Aravallis, and B, isn't that in a way contradictory to the recent Koregaon evictions that we saw, where you are evicting communities from forest land and then you are telling people that you can develop on up to 250 square meters? So how do I understand this?
Um, I think one way to look at that is, Amita Bhaviskar talks about this idea of bourgeois environmentalism. So it's a very elite approach to the idea of environmentalism. And that kind of strain runs through our laws, right? Even with the Wildlife Protection Act, you kind of have the situation where you prioritize the tiger over the tribals. And I don't want to, I think a lot of change is happening in the discourse, so I don't want to take away from that. I think a lot of young conservationists are changing the way we approach a lot of these questions. But if you juxtapose the Koregaon situation with, say, somebody building a villa on private forest land, and that's bona fide construction, and this is not. This is the only way to explain it is a very classist reading of environmental politics. And the Koregaon situation also is complicated because these are communities who've supposedly only recently come, right? So there's this notion of only Adivasis having rights over forest land, that they have this traditional connection and historical connection to the land. So that validates their claim to land ownership. Whereas the Koregaon situation is, migrants or certain kinds of people coming and sort of settling on this land as supposed encroachers. But if you look at it through a social justice lens, why is their claim any less legitimate than the Adivasi claim to forest land? And then you have conservationists saying, no, this has to be protected because it's a certain kind of particular patch of forest area. And at the same time, you have resorts. So it's where environmental politics only complicates matters, doesn't answer anything. But I, as a lawyer, have always veered towards supporting marginalized communities and their claims to forest land, because it seems like the most just solution to this very wicked problem. Because there's no way that you can like it's politically impossible to conserve forest areas without taking community rights on board.
I think that's a good place to conclude our conversation. At Newsworthy, whenever we speak to experts like you, we always end by asking if there is a book or a documentary or a paper or a publication that our readers should go to if they want to understand this wicked problem of conservation and development and forest rights, and just how entangled it all seems.
Absolutely. I think there'll be two books. It's hard to recommend just one book. I think one book would be, especially since we were talking about bourgeois environmentalism, is Uncivil City by Amita Bavaskar. That's a wonderful read to get a lens into how it plays out in urban spaces. And The Burning Forest by Nandini Sundar, if you really want to understand the politics of India's forests.
Perfect. Thank you so much for
Thank
your
you.
time. So I hope this conversation gave you some context, some more information about the amendments. I also recommend you watch our explainer on the topic, the link to which I will leave in the description. The Environment Ministry's proposal, these suggestions to change the FCA, can be found on its website in 12 languages. There are 11 days left before the deadline for public feedback ends, so do send in your comments sooner rather than later to fca-amendments at gov.in. If you have been listening, if you found value, do like, do share this video, and thank you so much for your time today.